record, 12:46 p.m.
Mr. Johnson, just to finish up about the affidavit, I referenced some cases. One is from Sean Cox, the case of USEVICZ versus Weltman, Weinberg, and Reese, case number 2022 CV 11890. If you search, it will be document 17, and in which the court held, it is well established that an affidavit, in quotes, is required to be sworn to by the affiant in front of an officer authorized to administer oaths. Affidavits may take place. I am doing such a bad job. So long as those declarations are made under penalty of perjury, certified as true and correct. So, and that's Worthy versus Michigan Bell Tel Company 472 F.APP X 342, 343, 6th Circuit 12, and Pollock versus Pollock, 6th Circuit 1988. The courts are holding that you've got to have those words penalty of perjury in your affidavit.
A federal court.
Yeah, this is a federal case, but you're saying because it's a state case, that doesn't apply. Is that your new defense?
I would prefer if you cited a Michigan Supreme Court opinion or a Michigan Court of Appeals opinion. I don't know if this Judge Cox, whatever you're talking about, is referencing cases in Ohio, Kentucky, Tennessee. I have no clue. So if you have something from this state Supreme Court, that'd be great.
All right, so you're saying federal law doesn't interest you, it doesn't apply?
To a state court collection case? No. It's a state case.
What's the basis of your belief that you won't follow it unless it's a state case opinion?
Because I'm in state court, so I would follow the state court rules.
If
there's a federal court opinion that's persuasive, I will use it in a case.
Great. So
like
tell me
the
the
Livonia Properties case, which I'm sure you're familiar with.
Tell me the state court, the state rule that you said you follow in creating. Tell me what rule that is again.
I don't know.
Well, what is the rule?
But you're talking about a federal case.
Fair
and
enough.
A federal opinion, and what you're asking about is a state court case.
All right.
So they don't mesh.
Okay. You specifically said you only follow state rules when you're doing an affidavit.
I know.
Please tell me which rules that you only follow when doing an affidavit in state court. What is that rule?
The state court common law about affidavits, whatever that is.
So that is what you follow when creating an affidavit. Is that correct?
Yes. Yeah.
Yes? You don't know specifically any rules, just common law. What specific common law?
I don't know. The common law of affidavits? I don't have cites on affidavits for you. I'm sorry.
Okay. So if the state law does require you put under penalty of perjury in an affidavit, you realize the state rules that you're following are being violated by you. Is that correct?
If you say so. You're the expert on telling me when I violated the law.
Nope. I have a question for you.
Sure.
If the state rule that you claim that's all you follow in creating an affidavit does require that it be stated that the thing is signed under penalty of perjury, you are violating that state law that you say you apply to. Is that correct?
I don't know. If that's true, then this affidavit, I don't know. I'm sorry.
You just said you follow state rules.
I follow state and federal.
Right.
Yes.
If they say you must have under penalty of perjury in the affidavit, you've then violated those laws. Is that correct?
If you say so.
Well, yes or no, because you seem to know what you adhere to when you're writing these. Yes or no. Give me a yes or no response.
To what?
If the state rules require you have a under penalty of perjury in the affidavit,
yeah,
and you don't, you violated those state rules. Is that correct?
Yes, if.
All right. And also you violated those same state rules in the affidavit you created for your client too.
If.
If what?
If what you said in your question is true.
Off the record for a second.
Off the record, 12:51 PM. On the record, 1 PM.
All right, moving on. We were just going to talk about, I think it's Affidavit 5 or is it 6? What do you have? What's this right here?
Exhibit 6.
All right, so I've named it 5. What do you have as 5?
I have a document. I'm not sure. It was,
Okay, so what is your 5? Do you have a 5?
he has 5 and what I marked as 6, I think, I believe.
Let me see.
1 and 6.
I don't have any. Oh, they're all in my bag. Took them out for whatever reason.
Exhibit 6.
Oh, I took them out. Yeah, that's not. You have it somewhere.
Maybe it's paper clips here.
This is 5.
Just
All right, so
take
this
'em.
should be 5 then. For some reason we named it 6.
You did hand it to me. You asked if maybe it was a double. I wasn't sure.
Bradley, I screwed up.
Oh, that's fine. We all screw up, but they
wrong
don't.
with
Screw
you?
ups don't turn into federal cases, right?
He almost had it. He should have just left it. Hey, we all screw up, buddy. Don't worry about it.
Oh. Well, when you've done what you.
Vinegar. Have you ever heard of that?
All right, so
Fly
let's
with
call this
vinegar?
5.
Yeah,
then.
I've
I'm gonna
heard of
say
that.
this is 5 for his purposes. Is that okay to say?
I've heard that before.
I think 6 may be this stuff.
Your exhibits.
I think I'm going to make 6 this stuff. We'll make
cool.
that 6 that we referred to. Unless, Bradley, did we make this exhibit? Do you recall?
I don't recall.
That was part of Exhibit 5.
Ay vey. All right, let's just.
There
Oh yeah,
you-
and I gave this to you, so that's
Here.
why. You're screwing me up here. There's Exhibit 5.
That's 6 that you just handed
What's
me.
5? What do you have?
5 is in your hand.
Boy.
They're the same thing. I apologize. That's what I'm
All
saying.
right. I'm just going on the numbers.
So
Sorry.
this is 5. Bradley, you have Exhibit 5 in front of you, yes?
If you say so.
Excuse me, Mr. John. Are we on the record?
Yes.
Mr. Johnson, you have Exhibit 5,
I have what's marked as Exhibit 5.
and there are page numbers.
Correct.
What is page 1?
As a
Please
motion.
identify it, then explain it.
Motion and verification for alternate service. So when we can't get personal service, we're going to try and get alternate service. And this is the motion that we filed
Okay.
to
And
effectuate that.
That's covered by Rule 2.105J?
If you say so.
Oh, you don't know?
No, I don't.
Okay. And you have, there's a verification of a
not.
process, guys, verification of a process server.
Yes, at the bottom, yes.
This court officer or associates have attempted to serve process on the defendant. Is that a Timothy Sutherland?
That's what it says.
And he has signed that he made at least 3 attempts, correct?
That's what he said.
And it says no answer at the residence. And when I say he made 3 attempts, he attempted to serve 1400 West 9 Mile Road, Apartment 8, Ferndale, Michigan 48220. Is that correct?
That's what it says.
And then number 2, that was 2:14, 3:38 p.m. No answer. 2:20:23, 8:01 a.m. He spoke with a female occupant in her 30s who claimed that this is the Underwood residence and she's never heard of this person.
Okay.
Did he discuss this with you,
No.
Mr. Sutherland?
Not that I remember. No.
Who wrote this then?
This looks like it's from Sutherland.
No, forgive me. It says, number 1, this court officer associates at the bottom of page 1. Did you type up this for the
No.
court?
No.
Who typed this onto the verification of the process server?
Sutherland.
So what part did you play in, I imagine it's a template or a merged document. What part did you play in entering the information on page 1?
None.
Who entered all this information?
Sutherland.
It says motion and verification for alternate service. You're saying that he filed the motion or wrote it for you,
Wrote it.
and then you signed your name to it.
Yes.
And you said you didn't ask him about the Underwood person. Is that correct?
I don't recall saying that.
Okay. Did you ask him about the Underwood person saying they're in the residence?
I don't recall.
Because you wrote, I declare that the statements above are true to the best of my knowledge, information, and belief. Do you see that at number 3?
I didn't write that.
Then you sign this and you don't declare that the statements above are true.
I do declare that the statements above are true. This is a lawsuit filed in the 43rd District Court. It has the plaintiff's name, the defendant's name, his address in Ferndale.
Yeah, I wasn't asking about that though. You signed this and you state, I declare the statements above are true to the best of my information, meaning you, knowledge, you, and your belief. Is that correct? You signed under that?
I did sign under that, yes.
And then you filed this with the court for within 14 days, I think the rule is, before the hearing or order was, hold on a second, before the order. Did you do that? 15. So you signed this and you entered it. When did you send this to the court?
There's a date stamp at the bottom. It looks
It's
like,
tough. It looks like
March 28th of 2023.
So it looks like it's timely within the 14-day rule. And then the court ordered, and correct me if I'm missing something, that an order for alternate service was allowable. Is that correct?
Yes, on page 2.
With what and it referenced 2.105 on page 2. Thank you. Well, let's go to page 2. Did you give this order to the court to sign?
Yes.
So you knew what 2.105 meant?
I can't cite it for you, but
I did give you the rule though, right?
that's what it says.
Okay. And so you're saying that you cannot reasonably be made as service of process. You couldn't serve him and you've made a reasonable attempts under 2.105. Is that what it's saying in a sense?
I didn't say that. The judge said it. This is the judge's order.
Oh, you just said you gave him this order to sign.
And he signed it.
Okay. So you checked off the box. 2.105, that's a regular merge format template.
Correct.
So he ordered service of the summons and complaint, first class mail
Yeah. Yes.
to this address, tacking or firmly affixing to the door. You tape the complaint to the door, correct?
If you say so, yes.
Is that what happens? If you know in your knowledge of 9 years of doing this, of 50 lawsuits a week, is that what happens?
Yes.
And then also it has to be sent certified mail return receipt requested to that same address, 1400 West 9 Mile Road, Apartment 8, Ferndale, Michigan 48220. Is that correct?
That's what it says.
What happens if you only do 2 of 3? Is that service effectuated under the rule?
I don't understand your question.
If you have 3 ways to, and correct me if I'm wrong, but this is a due process thing. They want to make sure that if the person's not going to be served, that they be properly notified in a way that's reasonably calculated to give the defendant his notice of the claim. So if you're not going to personally serve, you've asked that the court allow for an alternate service where you say and agree to, and the court's ordered, you must first class mail, meaning mail to him, correct? And then tack on his door, meaning put the complaint on his door. And then 3, certified mail, return receipt requested. Service is not effectuated unless all 3 things are done, correct?
That's what the order says, yes.
Is your understanding of the rule different from what the order says? Do you like to read the rule? Or do you know after 50 times a week of doing this?
There's like 10 questions there. Can you just pick one?
Yes.
Thank
Is
you.
that in keeping with the rule at 2.105? That 3 things must occur for this service to be effectuated under the rule 2.105.
That's what this judge ordered. Some judges cross out the certified mail. Some
Did
judges...
that happen here?
No.
Okay, do you know the rule as far as what must be effectuated for the client the defendant to obtain proper service in an alternate fashion.
Whatever the judge orders.
Okay,
Some judges order publication.
so well, the reason you get this explanation, because I asked you, is two of the things that the judge is asking be done, because he's ordering it, is service properly effectuated if you only do 2 of 3?
For this order, no. You gotta do
No.
all 3.
Thank you. So, somebody sent a proof of mailing certified receipt to the court. Do you see that at number 3, page 3?
Page 3 on mine is posting.
All right, what's your page 4 then? What's your page 4?
My page 4 is this. Is this what you are talking about?
Nope, keep going.
Oh, okay. So we're talking, can't even number right. Is this it?
All right, so write number 4 on that. So
Oh,
that we're
okay.
coordinating. Excuse me, stop. Number 3, write number 3. It should be 3. Sorry.
I'm going to give it to you. You write it.
Okay.
Can't even number properly. Yeah, it's funny.
Oh, that is number 4.
We'll get there.
Thank you.
All right. It's like when you did your amended complaint and you repeated paragraphs.
I
and
did.
Paragraph.
I screwed
Yeah,
up.
that
You're
was.
right. Yeah, thanks for that.
Yeah, that was a good one.
I did badly.
You did
Sorry. I did Bradley.
badly.
I see what happened.
We'll
here.
get to there too, right?
Okay. So let's go to, survey says. Let's go to number 3.
Okay.
Please identify what number 3 is and why it was sent.
Just want to confirm, this is the same number 3 you're looking at, right?
Yes, sir.
Okay, thank you. This is called proof of mailing certified mail receipt.
What's proof is being sent and why?
We are showing the court with this green card on the bottom right of the page that we have sent this certified mail return receipt to Mr. Ward at the Ferndale address
And
on
why
April
are you-
11th.
Sorry about that. Why are you doing that to the court?
'Cause that's what the court wants.
Okay, there's actually a rule that says you got to do that. Did you know that?
Gosh, you learn something new every day.
I don't know if that's true, but do you know that rule?
No,
No? Okay.
but we do it anyway
Okay.
because it makes sense.
Yeah. And number 4 I have is certificate of mailing, and it looks like it's your proof that the envelope, you were just regular mail to him according to the court's order, which says first class mail. And that's proof that you sent it first class, the complaint.
Number 4?
Yes, sir.
Yes, sir.
Yes. You're saying yes? That's showing the court that you did indeed mail it to the defendant at that address.
Yes.
Is service good on the defendant according to the court rules or the court order if you don't do anything further pursuant to the order?
I'm not understanding this question.
Okay.
Because it's...
If you had 3 tasks you had to do, and you've done 2 tasks. You've affixed it to the door. Excuse me. Oh boy, I am blowing this. This says that you've sent it to him, proof of mailing certified mail. Is that correct on number 3? Right?
3. Yes.
And then number 4, the reason I'm confused is because you've done the same thing twice, and I'm trying to figure out why. You
Why don't I
sent...
just tell you?
Okay, go ahead.
3 is us showing the court that we mailed it. Number 5 is us showing the court that an agent of Mr. Ward's at the Ferndale address signed for this summons and complaint certified mail return receipt requested.
What do you mean an agent?
If you look at your 5, look at the bottom right corner, there is a box checked agent. Do you see that?
Yeah,
Thank you.
I've seen it in some of your pleadings too, where you've been telling the court. In your initial disclosures, you said, I want to find out who the agent is that was signing for Mr. Ward.
Yeah.
Is that correct? That's
Yeah.
in your initial disclosures.
No, it's in my discovery plan.
Yes, that too, but it's also in your initial disclosures. And in your discovery plan, you actually cut and paste right into this discovery plan. Do you remember doing that?
I cut and paste from the discovery plan into the discovery plan? No, I don't remember that.
No, the actual receipt into the discovery plan. Forgive me.
Oh, I did, yes. I wanted the court to see that.
Okay, so let's go to the rules. What have you done with the rules? Come on, I gave you the rules.
I don't know. This is all I
Take some
have.
time to. No, you said you stuffed a bunch of stuff in your bag.
Oh, in my bag. Guarantee you have it.
Okay. I probably do, because I'm
Yeah.
a bad person.
You do. I have your client's credit report. Yeah, I don't have it. I'm sure you do.
I am positive you're right.
Yeah.
And here it is.
Oh.
Did you keep that compilation of the rules I gave you, or did you give that back to me too?
Oh boy.
I was trying to make it easy for you, and you weren't too happy about that.
I don't have it. You have it.
Okay.
You have everything.
So, when you saw that there was an agent signing for Mr. Ward, what did you do with that information?
You sent it into the court?
I mean, you didn't do an investigation to find out anything about the agent that you've now gone ahead and placed on some pleadings as something you need to discover? Did you do anything then?
No.
Why not?
Because we have a signed green card addressed to your client, Mr. Ward, and somebody signed on his behalf on April 14th of 2023 at the Ferndale address.
Okay.
So,
How do you know somebody signed for on his behalf?
because I'm looking at Exhibit 5 and there's a green card that shows that?
It says a box is checked off, agent.
Yes.
Did you check that box off?
Okay.
No, I'm asking, did you?
No.
Did you sign for the agent?
No.
And you're positive, because you've said you don't know a lot of stuff about this case.
I'm positive.
You're positive? Okay.
100%.
Why are you so positive?
Because you're accusing me of manufacturing
I'm
something,
asking-
and I don't like it.
You don't like to manufacture anything.
No.
Okay.
I do
good.
things by the rules.
Oh, let's look at the rule.
Yeah, let's.
2.105I says, agent authorized by appointment by law. Service of process on the defendant may be made by serving a summons and copy of the complaint on an authorized agent by written appointment or by law to what's the written appointment or by law that you depended upon when you told the court that he's representing by an agent?
That's a different court rule, brother.
No, it specifically is 2.105I. If you're going to receive service of
yeah.
process by an agent,
Yeah.
it has to be done either by, meaning
Meaning what?
he's the addressee.
Yeah.
So he's got to be placed on notice of the complaint, right?
Keep going. Yes.
Well, you always cut me up and say I asked too many questions. That's what I'm saying, all right? So in the 2 boxes on the green card, it says agent or addressee.
Yes.
So if he'd signed for it, he'd be signing addressee.
Correct.
If some agent signed for it, they check off.
That's exactly what happened.
But you told the court that he accepted service.
No, I did not.
Yes, you did. You just told me you did. Exhibit 5, I sent it into the court as Mr. Ward accepting service.
Where?
It says your proof of mailing is that you sent in a green card saying he accepted service.
Where does it say that?
Right here.
Where? We
there was-
addressed it to Mr. Ward, right?
Right.
Okay.
But Mr. Ward didn't sign.
His agent did.
You can't accept an agent signing unless you know by law he has an agent.
You're conflating court rules.
Which one am I
Subsection
conflating
I, like, that rule is for, like, CSC lawyers or the CT Corporation,
Yeah, the
where
cor-
you're GM and you have...
limited liability companies.
Right.
Yeah,
So
there's
we
a
didn't...
section for that. But
you're-
this is about accepting service for individuals.
What are you talking
In other
about?
words-
This was alternate service. Alternate.
It's all service, dude.
No, it's... wow.
You just agreed that 3 things have to occur for service to have been effectuated.
Yeah, I
We
agree.
just- right? So the third is...
Oh.
Sorry.
It is ordered. Service of the summons and complaint. And I'm referencing Plaintiff's Exhibit 5, page 2. It is ordered. Service of the summons and complaint, and a copy of this order may be made by the
LVL.
following methods. And we'll go to D. Certified mail return receipt requested to 1400 West 9 Mile Road, Apartment 8, Ferndale, Michigan 48220. That's what it says in the
So-
order.
Right. So did you send this to his agent?
We sent it to the address.
Right. But when you do it under 2.105, remember you got into a fight with me about 1 and 2, and I asked you specifically at the beginning of the deposition to read 2.
What are you talking
And
about?
2 says, sending a summons and a copy of the complaint by, let's call it certified mail, return receipt requested, and delivery restricted to the addressee, not an agent of the addressee, to the addressee.
This is where you're going. Okay.
So this has been signed by an agent. So when an agent signs, we go to 2.105. You know the rules, you told me. We go
This
to...
is all wrong.
Can I finish?
Go ahead.
We
but-
go to 2.105 to see if service is effectuated. An agent is only someone that is authorized by a written appointment or by law. You're on the phone again,
Yeah, so is your co-counsel.
but she's not on the record.
I'm not on the phone.
She's right. She's literally writing and not anywhere near a phone. Why-
I'm checking my phone.
Okay.
I can
But
multitask.
you're going to say you don't understand my question.
I do understand. The whole premise of your question is wrong.
Tell me where it says in 2.105 that this only applies to businesses, limited liability companies, corporations. If you could, I'll give you the time. Do you want to read it?
No, but there are other court rules about alternate service. This is not that.
Okay, which court rule are you referring to?
I don't know them offhand, but I'm sure there's a rule
Shouldn't
about
you when
alternate
it's your
service.
job?
And we followed the rule that the judge ordered.
Yeah, the judge ordered that you send it certified to the addressee. You had noticed that an agent had signed.
Oh.
So then you have to go to
Where's-
the rule, which is, I can hand you the rule, I can hand you whatever you want. I want to know why you sent it into the court that you had served the addressee, and the box isn't checked off, but an agent without first seeing if an agent is authorized by law to sign for him, or there's a written appointment. Did you investigate whether all of those apply according to the Michigan court rules? Or do
First,
you only follow federal rule?
what's your question?
Did you follow
one.
2.105I?
No, because it doesn't apply.
Show me why it doesn't apply. Because you know the rules.
Because we tried personal service under 2.105A. It was unsuccessful, so we went to the
It's
court.
2.105A1 as you corrected me. Go ahead.
A is 1 and 2. But anyway, so we didn't get that. So we went and asked the judge for alternate service.
We're
and
not
the-
arguing with that. I'm saying, why didn't you follow 2.105? It is not restricted to business, corporations, LLCs. In fact, when a rule is stated, it has to be place the reader on notice. So if it had said, when serving corporations, which it would, or serving a resident agent, which it would, then that would not apply here. This is serving individuals and corporations and LLCs. This whole 2.105. This is how you serve an individual, because there's nothing there saying it's got anything to do with corporations or LLCs. So when you are placed on notice, and you were, right? You saw that it said agent, and you
Okay.
didn't sign it for him, correct?
No.
Well, the reason I asked if you signed, I wanted to know that you had read that it is an agent, and you're saying you read it and you didn't sign it. It was already signed. Is that correct?
Yes.
So you knew it was an agent. Did you do the follow-up to make sure proper service to the, and I quote, addressee is made, and you,
What are you quoting?
the rules, you may not be familiar with them, but 2.105A2 requires only the addressee, not an agent. So if an agent signs, you have to go down to A. Let's take a look. An agent can sign if he's by written appointment or by law. Is there a law that allows him to have an agent be served and then he knows he's being sued? Is there a law that you know?
About what?
Do you want me to show you the rule? so
Can
you
I just
read it?
explain this?
How about you answer my question?
Because they're just going on and on.
No, I'm attempting to furnish you with the answers to your questions. Are you familiar with 2.105I?
No. Well, actually, I am, because we serve garnishments a lot. So yes, I am familiar with that.
Okay, and is that, who do you serve the garnishments to?
The CT Corporation, CSC lawyers.
Do you ever serve
on and
one
on?
person?
Sometimes, yeah.
That goes to my point.
What?
That's how you serve individuals, right?
Oh boy.
So
You are
where's the
really going down a
appointment
rabbit
or
hole.
law?
We followed the judge's order.
You did.
And we sent it certified mail, not restricted like in this paragraph.
I don't know what you're pointing to.
I'm going to point you to...
You either have him...
Stop.
Okay.
I get to talk. I'm going to point you to Exhibit 5, page 5. If we had served it certified mail restricted delivery, that box would have been checked. But it's not. It's blank. We just served it certified mail, which is what the court ordered.
Right. But
And we
service-
listed
Okay.
your Mr. Ward's address in Ferndale, which is what was ordered. And an agent of Mr. Ward's, like this. I know who lived in my house before I lived in it. If I received a certified mailing for this gentleman, I would not sign for it. I'm not his agent. I have nothing to do with this guy.
You're just narrating your defense.
Yes.
Let's get to the question.
Oh.
Where were your efforts? Did you make efforts, yes or no, to follow 2.105I that says you...
No, we didn't,
Can I
because
finish?
that court rule doesn't apply.
Okay, why does that not apply? Meaning, show me the restriction where it says, to what you said, it only applies for businesses, LLCs, or corporations. Where in that rule? May I hand you the rule?
I don't have the rule in front of me, but there are so many court rules about alternate service and how it's done and what you
Right.
have to do, and you're not citing any of those. You're citing a rule which mainly applies to huge corporations like General Motors, Ford, and all the rest.
So could you point to where it says that in the rule? 2.105I, where it just restricts it to businesses. You yourself just said you use the same rule to serve businesses and individuals. Why would you do that if it was just restricted to corporations?
We didn't serve him under 2.105I.
Yes, you did.
No, we didn't.
You depended on an agent.
No.
Therefore, you have to find out if an agent has a right to sign for him.
Wow.
Did you do that?
No, because we never served him under MCR 2.105I at no time.
Yeah, I know you think that.
Right.
But the rule is the rule. You have to follow the rules, right? State rules?
We followed the rules on substituted service,
You did.
which 2.105, whatever you've handed me, doesn't even
Yes,
talk
it does.
about. Where? Show me. Alternate
J.
service. Oh, J. Okay, discretion of the court.
Which is this a new argument?
There's no argument. It's just you're making.
Here, let me see this. I'll show you where you want to go.
Yeah. We followed the judge's order pretty explicitly, which
Well,
is...
you did for
Yeah.
two things, but you also received word that an agent signed, and you admit that that happened.
We?
You know an agent can't sign for him. What? That's the greatest. What evidence did you have that an agent can sign for him?
It was received. It was signed for. That's all we had to do.
Right, but it says an agent signed for.
Great.
What evidence do you have that an agent can sign for him when you accepted that and sent that to the court?
I don't have any. The postal worker did it. And somebody at
What do you
that
mean the
address
postal worker
signed for this.
What do you mean the postal worker did it?
We did it through the USPS. Certified mailing.
Okay, so that green
Two-
card you're now claiming is signed by a postal worker?
No, I'm saying it purports to be signed by an agent of Mr. Ward. I don't have the
Purport
printed
mean?
name.
What does purport mean?
Or means that's what I'm showing.
It's a guess on your part?
I don't. I wasn't there on April 14th in 2023 when this happened, so I don't know what happened.
What does it mean to you when an agent signs for something? Were you intending an agent to sign for this?
No, we were intending for your client, Mr. Ward, to get notice of this lawsuit. That's what we were intending. We were intending
so
to
how
follow.
did he get
Stop.
it from an agent?
I can't hear if both of you are talking.
Let
at
him
the same
talk
time.
first. He can talk first. Go ahead.
We were trying to follow the court's order. That's all, and we
right.
did.
Yes, you did by sending the certified mail, correct?
By posting it to the Ferndale address, by mailing it first class, by mailing it certified mail receipt requested. Yes, we did all three.
Right.
And we served him.
And the purpose is to get the addressee notice that he's being served and sued. Is that correct?
Yes, and this green card shows that somebody in that address took the package and took it to their house
So
in
you-
Ferndale on behalf
Do
of
you
your
know-
client.
So you know 100% then it was on behalf of my client and not my client. Is that your testimony?
No, but that's his testimony. He didn't live there at the time.
No, he didn't say anything. Can we stop? Can you read that back to me, what I'm questioning him on?
God, this
What
is...
exactly do you want me to read?
He just said that,
You want me to read back his answer?
yes, please. Thank you. Thank you. Sorry.
Give me a second here.
Dang it, though. This is all you got?
Service of process is all I need. You didn't
No.
serve
Would you
him.
like me to play it back, sir?
And
or
then
would
you
like me to-
defaulted him, and then you took his money without service. Yes, please.
I believe this is the question you want.
Okay.
Oh, I'm sorry. Yep.
Okay, it's the question before that and his answer before that,
Okay, I can do that.
because he's changing his answer. Yes. Oh, yeah.
Just one second.
I already sent this to you.
Yeah,
We're still on the record.
Oh, sorry. All right, so that's good. So your testimony, somebody took it on behalf of my client.
Yes, that's what the green card says.
All right, so you now know that he didn't receive, as the addressee, the complaint, because somebody else took it on behalf of him, as you testified, correct?
That's what the green card says. An agent of Mr. Ward took it on his behalf. That's
All
what
right.
it says.
And you got that card when?
I don't know. I'm
You're
assuming...
looking at the wrong page.
Oh. If you already know the answer, why are you asking me?
Because I'm an attorney.
Looks like we received it on or about April 19th of 2023.
Right, so that's when you were placed on notice that an agent had signed for him, correct?
We were placed on notice that our green card was accepted at the residence when it was addressed to Mr. Ward, yes.
Signed by who? An agent?
An agent of Mr. Ward's.
Great.
And believe me, I don't accept mailings for people that I don't know.
All right, we didn't ask about what you do.
And that's when normal people would not accept
What's
mailing.
normal? Is this going
Well,
back to somebody's gender or somebody's
I don't know.
how they behave, or what do you mean normal? Are
I don't
you
know
saying
what-
he's not normal?
What I'm saying is, if I received a certified mailing for somebody that I didn't know and
Right.
somebody that just some random
Did you
guy,
not tell me this? I didn't ask you
why are you interrupting me?
because you're not responding to the question, which is, when did you become aware that an agent had signed for Mr.?
On or about April 19th, 2023.
Okay, so you knew then that an agent had accepted this and he had not accepted or signed for this, correct?
That's what the green card says, an agent of Mr. Ward.
Right, and you sent it in anyway
Yeah.
as though he accepted service.
No, we sent it in to show proof that yes, we did send this Judge Hunt to Mr. Ward at the Ferndale address,
And did
and
Mr.
it was
Ward
signed
sign for it?
and it was signed for by an agent of Mr. Ward.
Right, so Mr. Ward did not sign that, correct?
I don't know.
Oh, you're saying he did sign it?
I don't know if he did or not. I don't know anything.
So
but
then
it
you
looks
can't say
it
he
looks
was-
I wasn't there, sir. It looks like an agent signed it because that's what it says.
All right, so you said on or about the 19th of April you became aware of this?
Yes.
And you, is it fair to say you sent that in to show the court that Mr. Ward had received notice of the lawsuit? Yes?
No.
No, you hadn't done that.
No, that's not what that sending the green card was supposed to show the court.
So there's no rule that says you're supposed to send that in to the court.
A green card?
Notice to the court that you effectuated service the way you're supposed to.
We were showing the court that we had complied with the court's order.
Great. And the order was that Mr. Ward receives the lawsuit by certified mail, yes?
No.
Oh, what was the order then? I apologize.
Service of the summons and complaint and a copy of this order may be made by the following methods. Certified mail, return receipt requested to the Ferndale address. That's what it says.
And what's the purpose?
Purpose of what?
Sending the complaint to that house?
To comply with the judge's order.
So not to place Mr. Ward on notice of the lawsuit?
Because the order for alternate service is supposed to give the defendant an opportunity to be heard.
Correct. And did the defendant sign for this, or was it an agent?
I don't know. I wasn't there.
Oh, so now you're saying the box is-
I can only tell you what is on the green card.
Right. And you testified that you were aware of the agent signing for it.
Purported agent, I wasn't there.
Okay. So did you then look at the court rules to make sure that that's acceptance under the court rules?
No,
no
because
matter what the court says, continuing the same question, we all have to follow the court rules. In fact, if you look at the order, it says under 2.105,
Okay.
right here, right below the signature of the court, and 2.105, if an agent signs for something, it must be either by law or by him authorizing someone. Do you disagree with what the rule says?
That's what it says, but there are other rules about alternate service.
Which rules are those?
I don't know off the top of my head. I can't give you cites, but I know there are.
All right, but the rule, whether it's connected to another rule or there's a proliferation of many rules, the rules are to be followed. Is that correct?
Yes, and they were in this case.
Well, you did not seek whether he was authorizing someone to sign for him, and it wasn't by law that an agent signed for him. And the rule specifically says it has to be one of those two. So you weren't following the law
No.
by just accepting an agent as the way he was served. In other words, did you know there was an agent at, was it Miss Underwood? Was that his agent? Were you thinking that?
I don't know. I was just, we sent a green card and somebody signed for it for Mr. Ward. That's
Yeah.
all I know.
But are you saying when someone signs a green card, you don't have to follow the rules?
What I'm saying is, at no time, at any time, did we tell Judge Hunt that we serve Mr. Ward pursuant to MCR 2.105I. At no time did we do that.
Okay. Is there a time when you're allowed to not follow the rules as an attorney? The court rules.
You would know.
Answer my question, please.
You're supposed to follow the rules, yes.
Right. And that means, there's an old axiom that says you're supposed to know the law. It's ignorance of the law is no excuse. You're an attorney that serves lawsuits every day under 2.105, whether you choose certified, mail, or personal service. That's correct?
We choose person.
That's your business.
We did not attempt to serve him restricted delivery.
Okay. But you're an attorney that has to follow the rules under 2.105. Is that correct?
Yes. That makes sense to me.
And you're agreeing with me that I does say he's got to authorize an agent, or by law an agent accepts. You're agreeing with that, yes or no?
Yes, that's what it says, but it does not apply to what this whole line of questioning.
All right, tell me why 105I does not apply to your recognition of whether or not he was served or not.
Because we followed the judge's order.
Yes, I know. And you're supposed to send it to him. If you get an agent signing it, that's your notice that there's an agent involved.
Look at 5 at the bottom. Who did we send it to?
Right. So if
Mr. Ward.
So if you say, okay, but it's an agent. Mr. Ward didn't sign for it.
I didn't send it to Mr. Ward's agent and said, Mr. Ward's agent, please sign for this. I
Right.
sent it to Mr. Ward
Mr.
and it was
Johnson,
signed for and
You're
received.
digging a bigger hole for yourself.
Thanks.
You sent it to Mr. Ward. You didn't send it to an agent.
Right, and somebody signed for
Right,
it at
so-
the address that he never lived at.
You should say, and I'm going back to what you consider normal, is say, oh, I sent it to Ward, but an agent signed for it. It's not a business, it's not a corporation. Something's wrong here.
No.
Oh, so you knew he had an agent?
Somebody accepted a mailing for Mr. Ward at that address, certified.
And you
Again.
don't know who?
No, I have no clue.
But you told the court you
stop.
did send
I
it
get to
to
talk. Again, if somebody sent me a certified mailing for the prior owner of my house, I would not sign for it. I would say, sorry, he doesn't live here, and send it back.
Right.
And that's not what happened in this case,
Would
right?
you have been served? Would that person been served?
Who?
The person that sent your...
The prior owner of my house?
Yeah.
If I refused it?
Yes.
No,
Why not?
because it wasn't received. And I'm not serving under 2.105I.
Right.
I'm not an agent of the prior owner.
Right.
Right.
Because it wasn't received.
But why would somebody
by
sign?
Mr. Ward.
Why
I don't
would-
know why people do.
Why
We're just
would-
following the rules?
Can-
I need both people to stop talking at the
All right.
same time, please.
I don't know why people do what they do.
Great.
They do what they do. You have a theory that people have to behave a certain way for you to consider them normal.
I just said what
You
I
said
would
that
do.
Yes. You weren't asked, but for some reason you volunteered.
Right.
So what the
I wouldn't
rules
sign
say,
for-
we don't care what Mr. Johnson's belief is on normal or what he would do if he was served.
Well, the jury
We
will.
have to follow the rules. And the rules say if you're aware there's an agent, you got to find out. Now, you didn't send it to an agent. That's part of what you're saying. But then when an agent signs for it, you go, well, obviously, Ward didn't get it.
No.
That's
That's
the
your
rule
argument.
is- no, that's the rule. Why did you not follow the rule?
I have said repeatedly, MCR 2.105I does not apply to this case at all.
So show me why it doesn't apply.
For example,
No, no. Let's
because
get the
we
rule.
were following the judge's order
Yeah,
for
yeah, but we're
alternate
talking about the rules.
service.
We'll get to that. Let's follow the rules. I'll hand you I, and you tell me why there's an exception.
There's no exception.
All right, then what is it you're saying allows you not to follow the rule?
Because it doesn't apply. We tried to serve him personally, and it didn't work, so we went for alternate service.
Great.
And the judge ordered it, and we
Yes,
effectuated
we've already
all
said that.
three.
Asked and answered, testified to.
Great. So
Now
why are
we're
we
moving
still
on to
it?
I. Why are you saying you don't have to follow I?
Because I'm not relying on I to say that I served your client, Mr. Ward, at any time.
But you received notice that an agent signed for him, not Mr. Ward. So you do have to follow 2.105 to tell the court he received a lawsuit and he's aware.
We served Mr. Ward pursuant to the court's order. I will just keep repeating that.
Yes, I know. Now moving on to I. You became aware there was an agent. The agency rule requires for service to be effectuated so that the addressee, and I'm quoting the rule,
It doesn't apply.
because why? Here's the rule. I'm going to hand you the rule. Tell me where the exception is for Bradley Johnson.
There is no exception, but I'm not, at no time did I say, hey, I served Mr. Ward's agent, I'm done.
Yeah, you did exactly that at page 5, at Exhibit 5.
You're just
You then
arguing
defaulted
with
him
me.
because he didn't answer the lawsuit that
Right.
he did not receive.
Again, we served Mr. Ward pursuant to the court's order.
Right. Don't keep repeating it. I accept that you believe that. Now,
It's true.
tell me what the Baxter Law Bradley Johnson exception is to not accepting service under I. What allows you to flout the rules and not follow I? Because the rules apply to us all, yes?
This I does not apply to this case at all. That's my opinion.
Well, opinions don't matter. Feelings don't matter. It's the rules that matter. So tell me where the exception is on your proof of service that allows
not-
you to flout I.
I'm not relying on I at any time
I know you're not. I need to know why.
because it doesn't apply.
It specifically says you've got to serve an agent that's authorized or by law. So he hasn't authorized it, and there's no legal reason. Why are you the exception to the rule?
Because at no time did I rely on I. We were relying on A. And then when A didn't work, we went for alternate service.
A actually says, as you know, because you asked me to keep repeating it,
Yeah.
if you're going to send it certified mail, as you did, it must be restricted to the addressee, which you did.
No, we didn't.
Okay, all right. You did. You said to Colin Ward only. That's it.
No, we didn't. If you look at 5, now for this, how many times? We did not check certified mail restricted delivery.
You sent it to Mr. Ward, right?
Yes.
And he is the addressee in your eyes.
That's what it says on the green card.
Okay. The rule says or, registered or certified mail. You send it.
We sent it
Certified
We
mail.
did not comply. Again, we did not comply with subsection 2. We didn't send it restricted at any time.
It says registered or certified mail. You sent it to him how? Certified mail. It says right there, look at the box checked off.
It says restricted too.
Look at the box on the green card. It says certified mail.
Yes, it does.
Right, so that's how you send it.
That's how we sent
And
it.
it says
'cause
you got to
that's,
send it to the addressee, which you did. You put his name on there, correct?
we complied with the judge's order. Just keep saying that.
Service is made when the defendant acknowledges receipt of the mail.
Right?
Did the defendant acknowledge receipt of the mail?
No, because we didn't serve him under that subsection.
No one's suggesting that you did. But to effectuate service, if you can do it by certified mail?
No, you're
You
just
know what?
wrong.
Okay, if I'm wrong, tell me what section you did serve it to him. You just said we didn't serve it.
Fine. Can we go off the record so I can look this up?
Off the record,
What
1:50
an
PM.
absolute.
On the record, 1:58 PM. Go ahead.
You want to take some time, Mr. Johnson, to review a rule that allowed you not to follow 2.105I, is that correct?
Yes, it's the very next subsection, subsection J.
Okay, be patient with me, I have to find it. Okay, it says, okay, go ahead.
Which is what we did on a showing that service of process cannot be reasonably made as provided by this rule. The court may, by order, permit service of process to be made in any other manner reasonably calculated to give the defendant actual notice of the proceedings and an opportunity to be heard.
Right, and that goes to the manner of service. Yes?
Yes, because when we tried under A1, it didn't work, obviously.
Let me stop you there.
Why are you stopping me?
Okay, go ahead, sorry, I apologize.
It didn't work under personal service, so as I said, we asked the court to serve him via alternately under subsection J,
Right.
not I.
All right, so the manner of service, you're pointing to J, is saying the court, under its discretion, and correct me if I'm wrong, may by order permit service of process to be made in any other manner reasonably calculated to give the defendant actual notice of the proceeding. Is that correct? And an opportunity to be heard.
And that's what it says.
That's what it says. And what you did is you did something reasonable. You sent it to this address with his name on it. Yes?
We did what the judge ordered.
Right. I agree with you.
Okay.
You shifted from J because originally you were going, we did what the judge ordered when I quoted rules. Now you're quoting a rule, and now you're going back to we did what the judge ordered. But I think let me finish. I think what you're saying is we followed J, correct?
We followed the judge's order, which I understand is under subsection J,
All right. So
not
you
I.
took the time to quote to me J
Yes.
as the justification for the manner in which you served Mr. Ward. Is that correct?
Yes, that's what the judge ordered.
All right. So he's saying send by certified mail. You keep correcting me. Certified mail, right?
Certified mail not restricted. Yes.
And you did that, correct? Pursuant to the order.
Yes.
And you directed it to Mr. Ward.
Yes.
And it came back that Mr. Ward didn't sign for it. Is that correct?
Again, I don't know. I wasn't there, but what purports to be is that an agent of Mr. Ward signed this on April 14th.
And you were aware of that April 14th?
I was aware that someone at the Ferndale residence received the summons and complaint on behalf of Mr. Ward, as it's purported to be in this page 5 of Exhibit
If I may ask,
5.
you said on behalf of Mr. Ward.
Yes, that's what an agent usually does.
That's right.
Right.
And why does an agent usually do that?
Because they're representing, or there's an agent relationship.
Right. And what was the relationship that you knew that Mr. Ward had with the agent that you just described as an agency relationship?
I have no idea.
That's
All
right.
I know is somebody accepted a mailing for Mr. Ward at the Ferndale address.
All right. And can you sit here before me and say that the defendant received it?
I don't know.
That's right. You don't know.
That's
And
right.
can you sit here before me and say
I
that you keep telling me that, and you had no indication that an agent could sign for him, is that correct?
We served it pursuant to the judge's order.
Right, but you did not have an indication that an agent signed for Mr. Ward, correct?
All I have is this green card, which is what it says.
All right.
That's it.
And also, getting back to your analogy about serving limited liabilities and corporations, what's the title you give the person who's an agent for a corporation?
Resident agent.
Right. And did you mail it to his agent or did you mail it to Mr. Ward?
We mailed it to Mr. Ward.
That's right. So you then received the word that an agent, you think, signed for him.
That's what it says on the green card.
And you had no indication that Mr. Ward received the certified mail that the judge had ordered, correct?
That's what the green card says. It says that
Right.
an agent of Mr. Ward, usually if an agent
I'm
receives
not going to
something.
waste any more of your time. The rule says what it says. You don't agree with that. But as an attorney, minimally, I would say an agent, what's the rule? Is that an acceptance? Do you disagree with that assessment?
I don't even know what you're talking about.
As an attorney, if I saw an agent had signed for someone, that would make me go investigate whether I followed the court rules, because it didn't go to the defendant. It went to an agent who signed for it. In other words, I knew that the defendant had not received that lawsuit when an agent does. The reason why an agent is set up is to make sure the agent does his job, that he is either contracted with the person or by law he has to accept. You had no indication of either of those, but isn't it true? You just sent the card into the court that you had done what you're supposed to do and served him.
Wow, great question. We served him pursuant to the judge's
All right.
order.
Okay, and we don't disagree with that,
Okay, why am I being sued?
because he didn't give you any indication that he had received service, and you learned with the agency that he didn't receive the lawsuit. So if I could quote the rule so that he could adequately present a defense, you then subsequently defaulted him for not answering. Is that correct?
After he was served pursuant to Judge Hunt's order for alternate service, yes, we did apply for a default judgment.
And you've said that he was served through an agent.
He was served pursuant to Judge Hunt's order.
Yes, through an agent. Yes?
I don't know. I
Oh,
wasn't there.
So an
I can
agent-
only tell you what's on the green card.
Right. So with that,
I don't-
with that uncertainty, you went ahead and said he was served, even though you knew he may or may not have been served. An agent may or may not have been authorized. You went ahead and told the court that he was served. Yes?
Yes, because he was
Okay.
served pursuant to the judge's order.
All right. What indication do you have that he was served?
We mailed it by first class mail.
What
Stop.
indication do you have that he was served?
We followed the judge's order. It was mailed by first class mail to the Ferndale address. That was never returned. We tacked it to the door of the Ferndale address. And we sent a certified mail receipt requested to the Ferndale address. And an agent of Mr. Ward's purported, according to this green card, again, I wasn't there on April 14th. I have no idea what's going on there. But somebody signed, I don't know if it was Mr. Ward, I don't know who it was. Somebody signed a letter for Mr. Ward as his agent. That's what it says.
So aware of what you just testified, you went ahead and told the court he was served, meaning by an agent, and then you defaulted him based upon that. Even though you just testified, you had no idea.
No, I disagree with your characterization.
Should we read it back?
I don't-
Anyway, moving on. I will try my best to get you out of here now. If you could just stop with the personal attacks, things would go a lot faster. Not telling you what to do. You can continue with the personal attacks. Your business.
Yeah, just following your lead.
I've yet to attack you at all.
3 years of attacks, buddy.
There's no... Were you attacked today?
Well, it's like 5-on-1, but yeah, whatever.
Who are the five?
We got your co-counsel, so we got Mr.
He hasn't
Ward,
been- he
and
wasn't
we
here the first hour and a half.
passing notes to you.
Okay, so who else is against you, you believe?
Well,
5
it's
on 1.
3-on-1, I'm sorry.
All right, and what has Mr. Ward done today against you that you feel victimized or...
Nothing, but it's
why
weird
is there
that
5 people on you? Are you saying the co-reporter and the photographer are against you?
I said 3-on-1.
No, you said 5 on 1.
Well, I correct myself. Can we move
right.
on?
You filed a... Upon learning that you had got a judgment against Mr. Ward went to court. I'll tell you, and you know this is part of the affidavit, and tried to figure out why he had a garnishment against him.
I don't know that, but I'll take your word for it.
All right, so you disagree that he did some work to try to figure out why he was losing his money in his bank account? You're saying he didn't do anything?
I don't know what he did. But whatever you're telling me, whatever.
Oh, well said. So we filed a motion, and you had discussions with Mr. Ward.
No, I did not.
You had no discussions, no emails, no faxes?
He emailed and faxed that he was objecting, and then I tried to have a conversation with him, and 2 hours later he said, "You're representing him."
So you tried to have a conversation by emailing him, by fax, by phone call?
Email.
Email. And what did you or he engage in?
He said, "Here's some objection," and it looked like it was an affidavit that you had prepared. And I'm like, okay. So I emailed him back and said, "I received it. I can talk to you about this." Radio silence from Mr. Ward. And then I said, "I reviewed everything. I said we're going to do a release of garnishment. If you want to discuss the case further, let me know." And then like 3 minutes later, he said, "You're representing him." And that was the end of any conversation I had with your client.
When I asked you a question, you for some reason pointed out that the affidavit he presented you looked like I wrote it.
Right.
Why did you say that?
Because Mr. Ward, I guess because you're fabricating damages, you made him do all this work, even though you were representing him the whole time. You made him do this objection himself, and fax and email and certified mail and all that stuff, so you could then write on your little affidavit all the damages you made up.
So you know all this information, like I made him fill out the objection to garnishment. I made him do that himself. How do you know that information?
I believe you prepared the objection because you spelled my first name wrong on the objection.
Do you have evidence that I did that?
Yes,
Or
I
you
do.
You believe?
No, as I stated in the Rule 11 motion, I have countless examples of you misspelling my name. I'm assuming Mr. Ward can spell my name properly.
You talked before about 5 people are against you in this room.
3.
And now you've reduced it to 3 people are against you in this room.
Yes.
Do you have this a personality or a prosecution complex where believing people always are against you?
No.
No?
But
Well,
I
you
see-
mentioned before how you lost your first job because of personality, and you've been quite rude and judgmental towards me, and you feel justified in doing that.
I do.
And there's
you've
several
treated me
approaches to take. Like, I really haven't engaged you purposely because that's an approach, but you want to fight and engage.
I do.
I would like you just to stick to the questions, if that's okay to ask. Is that okay to ask?
I heard you. I'm going to do the dep my way.
Okay. You said that you agreed to release the garnishment with Mr. Ward, is that correct?
Yes.
All right, just say yes. And what was your purpose behind doing that?
It looked like, upon review, he moved back in with his parents and didn't live at the address, so I wanted to make it right.
I don't understand what you just said. You, upon review of what?
The affidavit that I believe you prepared and all the documentation, I was like, well,
What
we better
specific
release it.
documentation?
I don't know, some email he had from his landlord saying he wanted a security deposit. Again, I don't know what happened with that. I don't know if he sublet it out and some friends from his restaurant were there. I have no clue. I'd like to figure that out.
Was the green card part of it in any way? You talked in terms of the affidavit. You believe that I created it, correct?
Yeah.
Is that a wrong or a bad thing to do?
Well, if you're representing Mr. Ward, why didn't you do the objection yourself? Why'd
You
you
didn't
have
answer my
him do all
question.
this nonsense?
Is that a wrong or a bad thing to do?
To have your client go improper when he's actually...
Asking the
Stop.
affidavit. I'm asking about the affidavit.
What?
You're saying it's a bad thing to prepare an affidavit for a client?
No, I didn't say that.
Okay, what was wrong about, if that was the case, about me preparing an affidavit for a client?
Because you're representing him and I'm not supposed to talk to a represented party? But if a represented party is reaching out to me, I don't know what that's about.
So the rule actually is if you're aware that he's represented, meaning I file an appearance, and you're talking about the FDCPA 1692C.
No, I'm not.
You were not aware of a representation of me, of him. In your head, you just said, this is a Parker affidavit, this has Parker fingerprints all over it. Is that correct? You didn't have an appearance from me.
And I got the confirmation 2 hours later that, yes, you were the mastermind, yes.
And that's because I had made an appearance when you received his information?
No, because your client emailed me and said, Mr. Parker's my attorney, don't contact me.
After you got that information from him, which you say I created.
After he emailed me on his own, even though he was represented by you.
I'm just, it's pure curiosity that you write hundreds, if not thousands, of affidavits for your clients for Velocity and this company, SCS, and you find fault with that.
Well, I'm representing them, so I'm their attorney. You prepared this. You obviously had a relationship with Mr. Ward, yet you're making Mr. Ward do all the legal work himself.
Sorry, what's the difference whether I'm representing him or not?
I'm not supposed to talk to a represented party.
And had I told you that I represented him when you talked to him?
No.
So you're fine. You didn't do anything wrong?
Well, it was clear that you were the attorney the whole time, right?
I don't know of that to be true. I don't know your timeline. I seriously, no idea. A case comes to me, I do what I got. All right?
Well, it was clear that...
I just wondered why you're pointing out the affidavit when you yourself, and apparently badly, write an affidavit for a client that doesn't even have the basic requirements that it be signed under penalty of perjury. So I'm curious why that's a problem if somebody else writes an affidavit, or is this part of that persecution complex?
It's just weird that you were representing him, you didn't file an appearance, you made Mr. Ward do all this work so you could then, in your great affidavit, say, oh, Mr. Ward had to go to court. Mr. Ward missed his time from work. Mr. Ward had to mail, fax, email, FedEx, all these documents to Mr. Johnson at his own time and expense.
All right, that's...
and that's exactly what happened.
So what were the things that you saw that made you release the garnishment, regardless of who gave them to you?
It looked like a big amount. It looked like your client was very upset. And, you know, that's why we have the court rule about setting aside defaults. Mistakes happen.
So which mistake did you make?
I guess we didn't know that he moved back in with his parents.
Your mistake.
Yeah, I guess. Everything was pointing to this address, but we didn't know he moved back in with his parents. I'm sorry. He didn't tell us that at any time.
He moved, and if it was his parents or not, are two separate things. He moved to an address.
Okay.
So he moved to an address, and you're saying on July 20th, when you received this information from him, you thought, whoops, a mistake has been made. Is that correct?
Yes.
But you have testified under oath that you received envelopes from early July that you had sent the wrong stuff to the wrong address. It had come back. In fact, I think one came back, Exhibit 4, returned to sender, not deliverable as addressed, and that's in May of 24. Yeah. Why did you not stop the garnishment? Because a mistake had been made, not go ahead and try to take his money because a mistake had been made? What was it about his information versus the information you got directly and not from Mr. Ward that you decided you weren't going to release the garnishment? What happened this time?
We had sent mailings to this Ferndale address the whole time. Everything was delivered. Nothing was returned. then finally, after we get the judgment,
Well, it was
hey,
determined.
I'm answering.
The address is right there.
I'm answering. Stop. So we thought, there's another address. We need to get this guy notice of the default. We sent it there because it came back finally from the Ferndale address after all that time.
May 24th, correct you did receive stuff back. It says return to sender. Look at Exhibit 4 again.
Okay.
And yet, did you then seek out another address for him? Now that you're on notice, it's the wrong address? Or did you just go ahead with the garnishment?
I don't know.
All right, let me show you. After receiving notice that it's the wrong address, this is what you did.
I disagree with your characterization that we knew it was the wrong address at that time.
All right, I'll use
In
your
May-
characterization. You made a mistake. Is that better?
Sure. I don't think we made a mistake.
I know you don't.
We did everything we could. But it's hard when you have people already that don't want to be served with process, when you have people like you telling them not to accept service of process and to fight them and don't do anything to help the other side. It's hard sometimes.
But you stay in the job.
Yeah, I gotta make money.
But why at this particular job?
I don't know. It's easy.
I mean, following the rules is easy, you're saying?
I've done personal injury. Wasn't for me.
Apparently, no, neither was the boss. Can you make
No.
this Exhibit 7?
I can.
You ever been fired?
I have not.
Okay. Well, whatever. It does happen, especially in legal offices.
3 months?
It was a disaster. They didn't have enough cases for 2 attorneys, much less 3.
I thought you said you left because of a personality problem.
Well, there were a whole host of issues. I don't really
What
want to
were
get
some of those
into
issues?
it. I don't want to get into it
Oh,
because
you
this
brought
is
it
going to
up.
be broadcast on YouTube. I'm not going to get into
Let me
that.
hand you Exhibit 7.
Sure.
Tell me, identify what that is.
This is a garnishy disclosure. Looks like it was faxed from Genesis Credit Union.
And what was the date they did that?
July 14th, 2023.
And normally, or if you know in this case, why was that sent to you?
Because the garnishee is supposed to send it to the court, to the plaintiff or slash attorney, and to the defendant.
And what is making them do that?
MCR 3.101.
No, what I mean is, did you send them anything that caused them to do that?
Obviously, we served them with a garnishment.
The date of the garnishment you sent them was the 28th of June.
Okay,
Does that sound familiar?
if you say so.
And yet you had received information a month earlier that you had the wrong address. Did you give here's my question, did you give them the new address?
No, we did not.
Why?
I don't know.
Is that your answer?
Yes.
So let's make this Exhibit 8, please.
I don't know when. I don't know when they changed the address.
Sir, yeah, thank you, I have your answer. Let me hand you what's titled Request and Writ for Garnishment. Is that
Perfect.
your handwriting? And what is that document?
2 questions there. This is my
Okay, no,
signature,
if they send it
and
to
this
Ken.
is a writ of garnishment, non-periodic, addressed to Genesis Credit Union.
What is the exhibit number you're looking at, just for the record?
Exhibit 8.
Exhibit 8, so that's a 9. And then we got another envelope that was returned to you from that same address tell me what, it's Exhibit 9. Would you be kind enough to tell me the date on that? So it's a second envelope that's been returned to you?
I can tell you it was mailed out on May 23rd of 2023, and we received it June 13th of 2023.
All right, so
apparently.
can you do the same analysis of that last envelope I gave you?
4?
I
It's
believe
the
so.
same thing.
Same envelope?
No, but
Okay.
it was mailed back to us on June 13th of 2023,
So
after
that's-
we had mailed it to them
Sorry.
on May 24th of 2023.
So there's 2 indications that you've got the wrong address before you're sending the judgment execution to the bank. Is that correct?
No,
Is that indication to you that you've made a mistake? You've got the wrong person?
no,
No? All right.
no.
What
Just
do you-
return envelopes? No.
What do they mean to you?
He's somewhere else.
Oh,
Everything else was current up until this point.
All right. So you went ahead and executed with his address after you just testified that you received word in May and June that he was, quote, somewhere else.
We had a judgment.
All right. So you send the judgment to somewhere else, correct?
After it came back bad, yes.
Yes. But then you went ahead and exercised on the judgment after you learned of the new address.
This all happens at pretty much the same time. This was mailed on June 13th. Mailed to
Relax,
us. I don't know
relax,
when we
relax,
received it,
relax.
and I signed the garnishment on June 16th.
All right.
So I don't even know if we got exhibits 4 and 9 before I signed this garnishment.
Great. So you're saying you sent it on June 16th, sir. Is that correct?
That's when I signed it.
So tell me when you send it.
I don't know.
All right.
We do
Is there
our
anything-
mailing every Friday.
Is there anything that will refresh your recollection?
Yes, I'm going to get out my calendar and see when the Friday was for the week of June 16th, 2023, and I can tell you exactly when we mailed it out.
Okay.
We would have mailed it out on June, well, I'm sorry, I was in 2024.
Again, if I may, just
We-
kind of relax, chill, please.
That was a Friday. We mailed it on June 16th,
And you-
2023.
And you don't have to show me, but you just referred to something that proves that.
Yes, a calendar.
Well, I don't understand calendar.
We do our court mailings on Fridays. We've been doing that in our office for years and years, so I had to look and see when the Friday was on June 16th in the year 2023, and sure enough, June 16th was a Friday, so we mailed it that day.
That's when you mailed.
To the court, yes.
Oh no, I'm saying to Genesis.
We mailed it to we served Genesis after it was issued to us on June 28th.
Yeah, see, that's why I'm a little confused. You keep pointing to this June 16 date when you, and I'm saying you're aware when you served Genesis in July. In fact, I think you sent it to them July 14th.
Okay.
So you're well aware you've got the wrong address at that point. In fact,
I'm not want to say it was the wrong address. Okay?
all right, was it the right address that you sent in? That you'd received at least 2 return
It was
to sender envelopes back a month prior?
It was the right address all the way up till the judgment.
Okay, I'll accept that. So after the judgment,
Phone's
it was
ringing.
the wrong address. I don't use my phone in a deposition. So you're saying after the judgment, it was the wrong address. If I may quote, could you quote, tell me what he said about it being the right address up until the judgment, please?
I can play it back for you. But
Yes.
It was the right address all the way up to the judgment.
That's exactly what the quote is. I just want to make sure I heard that right. I don't want to say anything improper to Mr. Johnson.
I can play it back for you.
Thank you.
So annoying.
Really? Oh, thank you. I'm not very organized today. I think you've got me flustered, Bradley.
Mission accomplished.
Oh, that's not very nice.
No.
All right, that's not very loud. Could you speak or say it so that he can hear that?
All right, was it the right address that you sent in? Did you receive at least 2 return to sender envelopes back from
It's the right address all the way up to the judgment.
Okay, thank you. I thought I was clear
Okay.
about that. Can I have the writ of garnishment back, please?
I'm handing Mr. Parker Exhibit 8.
All right. What is it you're saying? Small break, please, at 1 minute. Thank you. Rather than,
Give me a break.
Off the record, 2:29 PM. On the record, 2:30 PM.
okay, so just to reiterate what we're talking about, you're receiving envelopes back that are the wrong addresses. You're receiving, by your own estimate, that a mistake had been made.
It says return to sender not deliverable as addressed, unable to forward.
That's exhibit what?
Exhibit 9.
And what's the other envelope I sent you?
No. Exhibit 4. It's the same thing. Return to sender not deliverable as addressed, unable to forward. That's all it
and-
says.
Sorry. And the July 11th envelope.
I don't know what you're referring to.
Do you have all the exhibits? I have. It's such a small area, I can't. So I'm doing a bad job here. May I see
Yeah.
the exhibits? I gave you the one with the envelope.
Here, take everything.
Thank
I
you.
don't know what you're doing anymore. Do you?
No.
Yeah, that's what I thought.
Yeah, so we're missing a bunch here.
Do you want the envelope exhibit?
You nailed it.
It's exhibit number 2.
All right, so
It might be in your pile though. I think you
it's
took that one back.
usually I have a whole thing. I can just organize everything. Now I'm on the floor. Now I'm sounding like him. Jeez, it's your fault.
Yeah, everything's my fault. In your world.
We are still on the record.
That's fine.
I'm trying to move along. I got to find exhibit 2. This is going to be a nightmare.
If I could, I think it's in the pile you put on the floor.
What's
You're right, I see it. Thank you, Bradley. That's so nice of you.
Lovely.
Oh, there's exhibit 2. Let me hand you exhibit 2. And these are letters that you are sending in July, early July, because it says July 11th, that to Mr. Ward. Is that correct?
Correct.
And what dates are those envelopes sent out?
Looks like July 11th, 2023.
Both? Are those 2 different envelopes?
Yes, because there's. It looks like somebody took a photo of these. So yes, I'm assuming there are 2.
So you had sent 2 letters to Mr. Ward at what address in early July? Okay, so what other things, you seemed intent on being nice to Mr. Ward because you recognized a mistake had been made. What were those mistakes that you said had been made?
Well, when I received his fax, which I believe you had a whole hand in, it had emails to his landlord at the Ferndale address saying, "Give me back my security deposit." My new address is. Again, this all would have been really nice to have at the time.
At what time?
All we're trying to do with these collection suits is get the consumer to understand
What time would
us.
you want that stuff?
I'd like to have conversations with consumers so we can resolve these cases.
But Mr. Johnson, he did not know about the case until around the time he contacted you when he learned that his bank account was being garnished. So how would he know to reach out and give you current information?
Because we were calling him and leaving messages,
Okay.
and they weren't being responded. Actually, he would pick up and say wrong number.
All right, and what number were you calling?
The same number that he's always had.
Okay, and do you have evidence of this?
I do.
Did you provide them in your initial disclosures, the 400 pages?
I did not, because they're call recordings, but I can get them to you if you want.
All right, so let's go through Exhibit 8 again.
Okay, again.
Your signature,
Sure.
under around number 4, you're signing, what's the preamble there? Under oath?
No, it's
What-
easier if you and I both have copies so we can look at them together.
Yeah, I'm not going to waste more of your time by trying to be organized with the limited space I have. So
Yeah.
let's have you read it.
The space has nothing to do with providing copies, but it says, I declare under the penalties of perjury that this request has been examined by me and that its contents are true to the best of my information, knowledge, and belief.
So what information are you swearing? Is it fair to say you're swearing under oath?
Well, it's not notarized.
And then how important is that preamble above your signature to you?
Very important.
Is it true?
Yes, everything's true.
So what information you're swearing, even though you're aware the address is wrong at this point?
That's a mischaracterization of my testimony. I said that oh, it's on camera. You should really not do that.
Okay.
But as I said before, it's June 16th, 2023. These bad envelopes were mailed to us on June 13th, 2023, so I don't even know if we received them before I signed this.
Okay. So is it your testimony that, you're looking worried. Is it
I'm
your
not.
testimony that you had no indication that that was the wrong address that you gave the bank in the writ?
On June 16th, 2023? No.
You had zero indication at that point. Is that your testimony under oath?
We had some lady at the address say that she was a new tenant and that she had never heard of Mr. Ward. That's all. And that's very common in this industry. As your co-counsel can tell you, people don't want to be served with lawsuits. Friends, relatives will say, this person doesn't live here even though their car is in the driveway. All sorts of fun stuff. So yes.
Was that the case here? Was Mr. Ward's, I think you called it a Subaru Impreza, in the driveway?
I don't know. It was an
why would you bring
apartment
that up?
complex.
Okay, yeah, so, and are you saying that Miss Underwood, who signed, who your process server said back in March was the tenant at the time and said he didn't live there, are you saying they were living together?
What I'm saying is a denial of occupancy is not going to just tell me, oh, we got to stop right now. It's over.
What
we
does
got
it tell you?
Not much. If the Postal Service is saying that that's a good address, if we're receiving signed green cards from that address, if his car is registered to that address, it tells me he's probably there and they're covering for him, which is common and which is something that you have instructed your clients to do.
Mr. Johnson, you literally told me his car was registered to that address back in 2019.
Yes.
Why are you including that as a reason not to take Miss Underwood, who lives there, seriously?
Because if he had changed his address, it would be here somewhere. He would have registered
You're just
the...
pointing in the air to something. What
I
are you
am
doing?
pointing to, it's page number 9. I don't know what exhibit it is supposed to be attached to because you have done a really horrible
You're
job.
holding the stuff. What have I done?
You have done a really bad job of giving exhibits and keeping them in order, but this is page...
Literally, you read the number where I made sure they were chronologically done correctly with the number you're quoting and saying that I am not organized.
I am saying
What
that.
are you saying?
This
Are
looks
you
like...
okay? Do you need a break?
No, I want this done.
Okay, so you're receiving indications from Miss Underwood that not only does she doesn't even know who he is. You're saying in your estimation, she's just lying. Go ahead, you're right.
That
If you
doesn't hold a
lie-
lot of weight to me. No, it doesn't.
All right. Is it possible you're a little burned out
Today,
generally?
I'm fine.
Meaning you don't take anybody at their word.
I've been doing this a long time, and like I said, you tell your clients don't accept service, don't help the debt collector, don't do anything. I've seen them cover countless times. It's
All
not.
right. So
it's
that's
not
why you
because people don't want to be sued. They try to avoid it. It's
And
a
they
whole
shouldn't?
game. It's fine. Do what you got to do. I'd probably do the same thing. So it's not like
right.
I'm not sympathetic.
Well, thank
to,
you for that, the insight to your character.
Oh, perfect. I'm not done answering, so I'm going to keep going, if you don't mind. But yeah, it's a common thing in this industry. People don't want to accept service. They have their relatives lie for them. They say, oh, he doesn't live here anymore. I've lost contact with him. Or you're actually talking to the defendant, claims he's somebody else, even though his car's in the driveway, and it's harder with rentals because we don't have deeds or city records saying, yeah, the guy does live here, he owns the house, so I'll grant you that. And that's why the court rules have procedures for setting aside a default judgment, because this does happen. It's not, I didn't do anything nefariously or an error. It happens. It doesn't mean it's a federal lawsuit.
But you have agreed that mistakes were made by you.
At the time, upon reviewing what Mr. Ward had submitted, I'm assuming with your guidance and instruction, it looked like he actually did move back in with his parents, yes.
All right.
After we received the objection.
Okay, but you, again, swore under oath things that weren't true, like you have an indication, let me use their word, information, that he didn't live there. Your response, and I'll get to my question, is I don't trust people to tell the truth, like Miss Underwood, who had his car in her driveway, or was covering from him, or was his relative. Is that what you're saying? You had good evidence, the question is, that Underwood was lying when she said that to you.
No, but, well, everything else is pointing to that address. Everything. Cars
even the letters
registered.
that come back?
They came back after we got the judgment, but thank you for that.
But the letters coming back are indication to you that he does live there.
No, that's why we sent it to a new address. Oh, here's some more notes. It's like high school again. But to answer your question,
You said there was a...
I'm answering your question.
Sorry, sir.
Stop.
I think you already have.
No, I'm going to keep going.
I wish you wouldn't for your sake.
Well, I'm already head first. Let's keep going. You know, it does happen. But yes, if the Postal Service is saying this is a good address, if his car is registered there, if it's the most current address in our scrubbing, the only other address we had was an address that was associated with Mr. Ward since 2008, putting two and two together, I assume that was his family home, given the age of your client. And then assuming that, I don't know, people don't usually move back in with their parents. It does happen. I don't know what happened there. I don't even want to know. But, you know, when you're doing this job and you're trying to find people that don't want to be found, that don't want to be bothered, people that don't answer calls, say it's the wrong number, when you're telling them to not accept service, to not help, to not do anything, you know, that's what happens.
So you pointed
And your co-counsel can tell you that because she's worked in this industry.
All right, so you pointed to the fact that when Mr. Ward showed you emails with his management company, and that convinced you a mistake had been made, and you were going to release the garnishment. Remember that testimony?
Yeah.
So did you, based upon what you're telling me, because this is an apartment complex and hard to track down, I think you said leases or deeds, did you reasonably assume that you keep looking at him? Why are you looking at him?
Because he's right behind you.
Why aren't you looking at me? You were complaining that I wasn't looking at you before. No, you're not looking at me. Did you contact the management company?
No.
Well, wouldn't that be the reasonable thing to do, given your own testimony that it makes it harder with leases and serving apartments?
Usually they do go to the property manager and say, hey, does this guy live here? I guess Mr. Sutherland with this guy, Mr. Ward didn't do that.
So did you say to Mr. Sutherland, did you go talk to what you usually do, which is talk to the property manager? Did you say that to Mr. Sutherland?
No.
Okay, so you had no indication that Miss Underwood and your process server were incorrect.
Excuse me?
Your process server said Miss Underwood said Ward doesn't live there.
Okay.
I haven't heard from you any indication other than that you're fed up with the way people avoid service. I haven't heard any indication of Miss Underwood lying. You had said before that usually the process server minimally will go talk to the management company.
I did say that, yes.
Did or didn't do that here.
If he did it, he would have said he did.
So he didn't do that. You still have no indication then that Miss Underwood is lying. And your process server wrote, this is what happened.
No, I have a signed green card. It's your exhibit. It looks like Exhibit 5, page 5. I have a signed green card from an agent of Mr. Ward signing for this. So somebody at that apartment complex under...
You're not answering my question.
I'm answering the question. Somebody in that
Strike
apartment...
the question, please. And let me rephrase the question.
Oh, you don't like
I
my...
clearly said something wrong, and I need to be more clear with you. I apologize for that, okay?
You're just arguing your motion for summary. It's ridiculous.
I'm not doing any of that. I apologize if I'm somehow giving you that indication.
I'm going to answer.
Can I have, there's no question. It's struck.
Oh, because I was going to shut it
So,
down.
well, you can do that. Just let me ask the question.
Sure. Go
So,
ahead. Take your time.
let's see Exhibit 5, right?
No,
Your process server...
Exhibit 5, page 5.
No, looks like 1 to me.
Well, I'm looking at page 5.
Nobody knows why you're doing that.
Okay.
Just follow my
Oh.
guidance, okay?
Okay, perfect.
Exhibit 5, number 1. Your process servers, I think he's swearing under oath. Yeah. To the best of his information and belief, Underwood, in her 30s, claimed this is her residence. She's never heard of Mr. Ward. Do you need to read that, or do you agree it says that?
Well, that's what she said, apparently.
And did you, this is my question, and this is March 15th, 2023, did you have any evidence that she was lying on March 15th? Mr. Johnson, let me stop a second. It's actually February 20th, 23.
No.
Did you have evidence on that date that Underwood was lying?
I had postal verification showing it was a good address. I'm showing that his vehicle is registered there.
In 2019?
There was no other registration for this newer car, an Impreza. I think it was a 2018. Previous mailings to this address had not been returned. We had a good postal verification. I don't know if I said that. It just looked like the most current address. And yes, people do cover. It does happen.
I agree, but did you have proof that she, I don't know where you got this word from, cover or lied? Do you have proof of that?
I don't, but like I said before, a denial of occupancy by an occupant is not going to stop this without some further substantiation.
Okay, so a return to sender of envelopes is or isn't further substantiation?
That's a good one, but a signed green card from an agent of
Well,
your...
we can talk about that, but
No,
answer my
we've talked
question.
to death.
Answer my question.
It came back bad. Those mailings came back bad. The only other address we had was the one we sent it there. That's it.
And did you get those letters back?
From...
Yeah.
No, because Exhibit 2 is your client taking a picture of said envelopes.
So the answer is you didn't get them returned to sender.
The mailings to... Yeah, it's pretty clear. He got them because he wrote on them and took
All right.
a picture of them and sent them to you.
Okay.
Okay.
And then you served Genesis after that with the wrong address.
I have to look. Yeah. Again, these were mailed to What am I saying here? All right, we sent these on July 11th. She was served with it on July
Goodness gracious.
14th.
When did you get that address that you sent it on July 11th? Just because you sent it on July 11th doesn't mean it happened. You could have got that in June 11th. When did you get?
I don't know.
Yeah, I got you. So you sent the mailings to an address you knew or suspected was his address. I think you keep saying when he moved back in with his parents, and yet you sent Genesis a execution of judgment after that. I don't know when you got that, and you claimed, I've got all the information and it points to this address. So did you lie when you said that?
Did I lie what?
When you told the court and Genesis the wrong address?
No.
But then why did you mail to his West Bloomfield address, which is nowhere to be found in your
Because
pleadings?
we finally got back the bad envelopes that were returned to sender, not deliverable as address, unable to forward. So we found the only other address and mailed it there.
You have to be careful of what you ask if you don't know the answer. Never ask the question.
Oh.
Okay. Well, let me see that. Okay, so you're telling Genesis he's from the address in 9 Mile at the time that you're aware he has another address. Isn't that correct? According to those envelopes that you've sent.
No, I don't know when this garnishee disclosure was drafted. I don't know when the packet was sent to Genesis so that they
Make
could
this
receive it.
exhibit, 10, is it?
I have no idea when that happened, but I'm sure you'll tell me.
I'm just using your documents, sir.
Oh.
I'm not telling you anything.
Yeah, great.
All the dates on the other page.
Oh.
Oh,
Is this exhibit 10? Did you see exhibit 10?
I'm seeing it now. Oh, it was served on July 14th.
So you do know now that you served a garnishment, a writ of garnishment after you knew that the writ of garnishment had the wrong address. Is that correct?
I don't know that. I don't know when the process server received the packet. And no, we did not call the process server after we got this exhibit 9 and exhibit 9 and the other one with the envelope. We didn't call them and say, oh, well, we made a mistake. No, we didn't do that. So there you go.
Okay. You keep saying we, but it's you are running the show.
We, the royal we, the firm, everybody that works in the office.
Baxter doesn't work there, and you're signing everything. So
Okay.
it's you that made the mistakes.
I'm the attorney,
the debt
yes.
collector.
I represent the firm, yes.
Okay. Is Baxter aware that you're litigating this case?
Yeah.
Mr. Baxter, sorry.
I'm not, attorney-client, I'm not getting into any of that.
I did not ask you to.
I'm not getting into it.
So you can't,
I'm representing the firm. I'm not talking about anything, discussions with another principal of the
I
firm.
don't want you to.
Good.
Does he know about this lawsuit?
He does know about it, yes.
How does he know about the lawsuit?
I put 2 and 2 together.
I don't, some people assume things that aren't true, so I don't do that. I'm asking
I
you.
can't answer your question, so
Because
figure
of
it out.
attorney-client privilege?
Bingo.
You are representing him as an attorney?
He's,
you
the
represent
firm is my client.
I asked you about Mr. Baxter. I didn't say the firm.
He's a member of the firm.
Okay, great. But about Mr. Baxter, do you represent him?
I represent the firm. You didn't
Okay.
sue him.
In this case, do you represent the firm? I didn't see your appearance.
I represent the firm and myself.
All right, so you filed an appearance for the firm.
Yes,
Yes?
I did, yes.
Okay, so you feel like I'm asking you questions about the firm when I ask you about Mr. Baxter. Is that correct?
Mr. Baxter is a member of the firm. I'm not going to tell you discussions I had with members of the firm, which is my client. If you have a problem with this, you can go talk to the judge.
No, I don't have a problem with anything.
Okay, then move on.
It's not an LLC. It's a professional corporation.
Okay,
So there are no members.
perfect. The principal, owner,
So he's a principal and owner.
yes.
All right. And you represent him individually or the firm?
In this case, I represent myself and the firm.
Okay.
And Mr. Baxter is a member of the firm, and any member of the firm is my client.
Okay.
So I'm not going to get into discussions I had with my clients. I'm sure you can appreciate that.
Okay. So you have, you don't want to talk about him personally because you think that there's an umbrella there. And I respect attorney-client privilege.
No, you don't, because you waived it in this
Okay.
case.
So, so you
It's true.
have appeared for the corporation and appeared for you. In one of the initial disclosures, you said that, I don't know why you said the insurance covers your representation and defense, but you're self-funding. You're not using insurance. Is
That's-
that correct?
100%, yes.
Is this, the firm makes that available to you? Or do you have a separate insurance that just covers you?
It's like 10 questions. Just pick one.
Is there insurance that covers you individually?
Yes,
And why have you not elected to take it?
because we don't want our premiums to go up. Because prior, you have said, I'm going to sue you, and you're going to get your insurance involved, and they're going to pay me. That's what you said.
Okay. You can say whatever you want.
And that's true.
I don't know from your insurance. I did not know you were covered by insurance until you represented in federal court that there's insurance. I did not know. I frankly don't know how that works. You don't have to believe that or not. So it's not something I would have said to you. So you've just identified the insurance availability on a federal pleading. That's what I'm asking you about. We're in a federal case, correct? You've
Yes.
chosen not to do that
Correct.
because you don't want the firm's premiums to go up.
Because I want to represent this myself, because you are who you are, and I don't want another attorney coming in here and messing it up like has happened.
I
I
respect
want to
that.
take you on, and I'm doing it.
You want to take? Were you about to say take me down? You
No.
were, weren't you?
Well, that's what you
We say
said.
things, but we get emotional when we say things.
Yeah,
And why did you not use the word down? You were about to say take me down. Why didn't you do that?
I want to take you down too. I'm
Okay.
under oath,
Okay. And
because you annoy me.
well, I know you have these assumptions that you make about people and why they lie to you or why they annoy you. And I'm doing something that bothers you, and I respect it. Your opinion,
And
you
you-
can have your feelings. But do you understand that you might be better off with an attorney representing you, or you don't?
I'm doing this my way.
All right. And I've asked you, are you going to have an attorney? You said, no, I'm going to be doing it myself. Correct? I gave you that option.
You did.
All right. Fair enough. That's just housekeeping.
Oh,
So let's bring this to a close. Something you want to tell me?
Where's the last page, but I think you wanted to share.
You got to know the answer. Okay. I'm going to teach you a lesson.
Okay, don't teach me a lesson.
Are you all right? Okay. Is that oh, I'll wait till you're off your phone.
just tell me how much longer this is going to take.
I'm going to try and get it done real quick. You just got to stop with the personal tax. That takes time too. Everything you want to say to me has already been said. So,
Well, I want to say it for the record.
yeah, but I'm saying you've already said it. So let's speed it up. So, do you think it's reasonable to expect I think you talked about there's a protocol in force for when you're trying to when you're doing something that reasonably is calculated to serve somebody, is it reasonable to expect Mr. Sunderland to go talk to the management company?
I said that's what he does on a lot of these. I don't know why he didn't do it on this one.
So he works for you a lot.
Yeah.
Okay. Did he perhaps sign that green card on page 5?
I don't know. That'd be pretty crazy if he did.
All right. You don't know. Nobody knows. I'm
Nobody
just asking
knows. The postal. Nobody knows. But somebody at that address accepted this package to Mr. Ward, which is odd to me. If he never.
Yeah, you've
If he didn't live
espoused
there.
a lot of your opinions through this, whether they're correct or not, who knows. I should have specified a bigger table. Forgive me, I gotta ferret through all this that's on the floor. I forgot to ask you your full name, Mr. Johnson. What is it for the record?
You have my driver's license. It has my full name on it.
I don't have it in front of me, if you'd be so kind.
I'm not answering that since it's on YouTube.
Okay. What's the objection you're placing on the record that you are required to say to not answer something? Is it attorney-client privilege?
You have said to me that you're going to broadcast this on YouTube, even though I've explicitly told you not to, because I have been subjected to death threats, which you said I deserved.
I did not say that.
Yes, you did, and it's
Okay.
on tape. But you took the call recording down because I had, because obviously
So
you
is
made
it
a
on
big
tape, or
mistake.
you said it's on a...
You have possession of it, and you destroyed it, and you can produce same if you have it, and
Do you
you can.
find yourself making assumptions and thinking what other people are thinking is true? Are you always reading people's minds? Is that what you believe? Why they do things?
Well, that's pretty easy with you, because you
All right.
put attorney-client privileged conversations on your YouTube channel, because you recorded a conversation with me on your YouTube channel, yet you took it down, yet some are still up. It's pretty obvious that you are breaching the attorney-client privilege on a lot of cases with this YouTube channel, which I don't get, but since you said you're going to broadcast this on YouTube, and I told you I don't want that, it's called doxing, D-O-X-X-I-N-G, and I'm not going to play that game.
Mr. Johnson, you said that I had told you I was going to put this on a YouTube channel.
Yes,
Yes.
you did say that
And
many
then
times.
you and I had a discussion about that, and you said, okay, but leave out the parts of my address and my family. Is that correct? You didn't
yeah.
mind it, just
No.
don't have the privacy.
No, I
aspect.
said never broadcast it on YouTube. I said if you want to do a video deposition, that's fine, because, I'm just me. This isn't a big case, but I don't want you to broadcast this on YouTube at all. And you said no. And when I said why, because I get death threats, and I don't want my address, I don't want personal information on my name being broadcast on the internet. I'm sure you can appreciate that. And you laughed in my face and said I deserve the death threats because of email tone.
This is the first time I've seen you in about 6 months. When did I laugh in your face?
I saw the video. I saw your call recording.
All right, so when
You
did I
were
laugh
pointing
in
your
face?
finger and you were really mad.
When did I laugh in your face?
And you did it in your video about this case.
Were you there in this video?
I watched it.
So you think that I know that you're watching my videos? Is that another thing?
I know you do, because I've commented on them, and then you said you were going to go to the bar, go to the local authorities, file a personal protective order against me over
Alright,
a
that
YouTube
was happening
comment.
because you were being a little bit impulsive and constantly emailing and faxing us and just contacting us all the day, every day, which I sent you a letter saying, please back off.
Oh.
because you were getting a little extreme.
Because you didn't follow a
That had
court
nothing to do
rule.
with my YouTube channel,
Because you filed a motion in federal court.
which
and the-
justifies contacting me all day and emailing
And the
me all day.
Let me finish. And the local rules under 7.1 specifically say you must seek concurrence before filing any motion. You did not do that, and I called you and told you,
You
I
are
don't
right.
I don't appreciate that.
If somebody breaks a rule like that, I should call them and email them and send carrier pigeons to them. You're absolutely right.
And this-
That justifies your behavior. I apologize.
And there are more issues too. You have emailed me a motion. It was rejected because the file size was too big. You knew I didn't get the motion, and yet, did you correct that at all? No, I had to find out about it.
Exhibit Lee Rambles, 11, please.
I had to find out about it on the court's docket, and then
Oh,
you
is this
said,
it? I don't want to.
Well, he's answering. I need him to answer and nobody else to speak, please. Thank you.
you said, you know, so it's just a constant thing with you. You can't mail things properly. You FedEx to P.O. boxes when the air bill tells you not to do that. It's just a common thing. And you do it all the time. And look at your exhibits. Look at how this deposition has been conducted.
Are
Go
you done,
ahead.
Mr. Johnson.
I'm done now.
You need to do it now. Off the record for 2 minutes, please.
Off the record, 3:06 PM.
Do you want to